In Chapter 2, we're going to talk about the role of the courts. And again, we're going to skip the feature case because we're going to talk about it in class. So the federal Constitution establishes 3 branches of government. So we have the executive branch, the legislative branch, and the judicial branch. And each of them are supposed to operate as a check on the power of the other branches. The idea here is then that no one branch of government has more power than the other. Also, federal and state governments operate as a balance of power in the federal system of government as well. So we have what's called an independent judiciary. So the courts monitor and restrain the executive and legislative branch based on whether or not their behavior violates the Constitution. So in the federal system, judges enjoy what's called lifetime appointment. So they can only be removed from that position for a major crime. And then what happens is they're impeached. So I know impeachment has been in the news recently, but it's important to understand that an impeachment is not a conviction or removal from office. It's basically an indictment for a trial. State judges do not enjoy lifetime appointment and are selected by a variety of means. So in some states they're elected, in some states they're appointed, and then in some states they use this Missouri method where they're first appointed and then after like a year or so they're up for election, and the election is only to determine whether or not you want to retain that judge. So they're basically confirmed by an election. Here's a typical court organization chart. We usually have a Supreme Court of some type, one or several courts of appeals, and underneath each court of appeal, several county trial courts. So federally speaking, our highest court is the state Supreme Court. And it generally hears only appellate cases, although it does have original jurisdiction in some cases. Below them are courts of appeals, and this is usually where most appeals end. Okay, there are 12 regional circuits, sometimes called circuit courts. So you might hear, a court opinion out of the Ninth Circuit. And then beneath those are U.S. district courts. These are regular trial courts at the federal level, and there are 94 district courts. At the state level, states follow pretty much a similar level. They generally have a highest level of court, a state Supreme Court. They might have a state court of appeals. They might have a state superior court, which is a trial court that hears felony cases. They might have district courts that hear misdemeanor cases, but not all states have both of these. And then there's generally a small claims court or a magistrate court that hears minor cases, sometimes traffic offenses. Those are generally heard before a magistrate. Now, a couple things to keep in mind. Under state law, the government has a limited time to bring charges against an individual for a crime, and that's referred to as a statute of limitations. There is no statute of limitations on murder, but for most other crimes, there's a period of time after which you can no longer bring charges. It varies from state to state, and some states do not have a statute of limitations, or some states, I believe Kentucky has no statute of limitations for felony cases. So what is the purpose of a state court? State trial courts handle most cases, even those that don't go to a formal trial. Here they're determining whether or not someone is considered guilty or innocent of a crime, and they're going to rule as to what types of evidence are admissible. A court of appeal is going to review a trial court. So say there's a legal issue that has come up in your case, if you're going to appeal that, you would take that to your state court of appeal. And then there's generally a final review of state trial and appellate cases in a state Supreme Court, which functions very similarly to the U.S. federal Supreme Court. At the federal level, we have federal district courts. They hear cases involving federal crimes and civil cases when warranted. Again, there's a court of appeals, and then we have the U.S. Supreme Court, which rules on the constitutionality of laws. Now, that comes from a very famous case, Marbury v. Madison. So in Marbury v. Madison, the Supreme Court reviewed a law involving the appointment of a federal office holder. Marbury had been appointed or offered a federal judgeship, and the president, who was a new president, refused to give Marbury the job because of political differences. So Marbury argued that he was entitled to this judgeship. The Supreme Court declared that Marbury would be entitled to the job, and they could order the president to do so, but the law establishing the position was unconstitutional. So basically, we'll talk about this in much more depth in class, but this creates the doctrine of judicial review. And that's the power of the Supreme Court to review laws and determine if they are constitutional. So when an appellate court decides how a law should be applied, it's called a precedent, okay? And that is because then that ruling serves as a precedent for how that law will be interpreted. So under the legal doctrine of stare decisis, precedents, are binding on future court decisions. So let's think back to the case in Chapter 1, Mapp v. Ohio. Once the federal Supreme Court said that evidence that's obtained legally cannot be used in trial, that's a rule for all future cases. So what are some standards used in court? One is the contemporaneous objection rule. Any objection should be made before someone answers. So when an attorney asks a question, you need to make the objection before the respondent actually answered. Another standard we might hear is what's called a prima facie case. The judge has to consider if a minimal amount of evidence is present. Prima facie means on its face. When we're just looking at the case, is there enough evidence present to proceed? We talked about preponderance of the evidence and beyond a reasonable doubt before, although we never defined preponderance of the evidence. That's basically a little more than 51% of the evidence needs to point towards guilt. And we know that beyond a reasonable doubt is what the prosecution must show in order to prove guilt. After someone's convicted, there are generally other court proceedings. So generally, most people will file a direct appeal. And that's where the defense appeals from the conviction at trial. Appeals, however, are not based on matters of fact. It doesn't matter if you're innocent or not. Appeals are based on matters of law, and that's why those objections are really important, because you're appealing based on something to which you've objected before. Now, if you didn't object to it, you can't appeal based on that. When we do appeal, the defendant is now called the appellant. The prosecution is the respondent. The trial records are called the clerk's transcript, and a word-for-word record is the reporter's transcript. So a first appeal is typically granted as a matter of right. Each side is going to submit a written argument for or against the appeal, and these are called briefs. Now, because there is an error, that doesn't mean that you're automatically going to get a new trial. You have to show that the error affects the verdict of the trial. If it's a harmless error, the conviction stands. There's also discretionary appeals. These are second appeals to a higher court, and the appellate court has an option to hear an appeal or not. Usually you're only going to reach the Supreme Court after exhausting all other appeals. And then what will happen is your attorney will file asking the court to issue a writ of certiorari. And this writ of cert is an order from a higher court to a lower court requesting its records. So when the Supreme Court decides to hear a case, they issue this writ, and it orders the transcript and all the records from the lower court to be brought up to the Supreme Court. So it basically means that the court will hear this appeal. Some other things to think about. Informa pauperis is a waiver of any formalities. An amicus curiae is a friend of the court brief. So this is a petition or a brief submitted on behalf of one side or another. The ACLU often does this. Then the court will hear oral arguments from opposing counsel, and then a majority will write its decision, or what we refer to as the opinion. Okay. Habeas corpus is the great writ. It's a civil suit challenging the right of the government to hold a party in custody. So this is often used for what is considered an illegal arrest, a failure to release, or lack of counsel. And this is a civil action, not a criminal right. Congress has limited access to courts via habeas corpus, and this is part of the Anti-Terrorism and Effective Death Penalty Act of 1996. The Civil Rights Act of 1871, Section 1983 applies when state, county, or city officials deny a citizen their civil rights, and Section 1985 applies if government officials are not involved. So the Bivens case, in this lawsuit filed against federal officials for a civil rights violation. And this is referred to, the actual case is Bivens versus 6 unknown narcotic agents. So in this case, federal narcotic agents searched a home without a warrant and arrested Bivens. After the charges were dismissed, Bivens sued the agents, claiming that his Fourth Amendment rights against unreasonable search and seizure were violated. The Supreme Court recognized a new cause of action, Bivens, referred to now as Bivens, when federal agents violate Fourth Amendment rights. And this is a civil, not a criminal remedy. And And that wraps up Chapter 2, the role of the courts.